Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action?
May it please the Court. Yes, the Equal Protection Clause of the 14th Amendment prohibits race-conscious affirmative action. The original purpose of the 14th Amendment was to give freed African Americans equal standing with the rest of society because of their unique history of slavery. However, it was not meant to give them an unfair advantage against other races. The framers of the 14th hotly debated on whether it should be used to draft and pass race-conscious legislation. We agree with those who thought of its usage to be a stretching and misuse of its original purpose. A commonly held opinion was that with the passage of the 14th Amendment, African Americans were granted the same rights, privileges, and immunities as other citizens. Therefore, any extra assistance or affirmative action would overextend the limits of the Constitution. To further expand the 14th to allow for race-conscious affirmative action would be going against what it stands for.
How does legislation enacted by Congress in the 1860s and 1870s affect your answer to question number 1?
Although it may be tempting for some to argue that the creation of the Freedmen Bureau is indicative of a historical precedent favoring affirmative action legislation, in reality, it was only passed to equalize and help smoothen the transition into a society for African Americans recently freed from slavery. To say that the condition of African American youth today is proportionate to the condition of African Americans in the 1860s and 70s would be a massive hyperbole, and invalidating the leaps of progress that past generations have made. The Equal Protection Clause has served its purpose to raise African American standing in society and prevent discrimination. Any further use of the clause to justify affirmative action would be antithetical to its purpose.
Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 1870s. Would that argument still work more than 150 years later in a very different society?
If the framers of the 14th Amendment approved of race-conscious legislation in the 1860s and 1870s, they would disagree with its application in today's society. Legislation passed then was meant to level the playing field and create equality for Black people who were brutally and consistently discriminated against. It was not to promote inequality and create unfair advantages. Today, the impact of that legislation has resulted in dramatically different societal conditions, and the use of the 14th Amendment to continue the implementation of race-conscious legislation is not only untrue to the intent of the framers, but also unconstitutional. The framers were no strangers to temporary legislation. They agreed to the Freedmen's Bureau only lasting a single year, and even with the extension of its lifespan, the Bureau was only in full operation for 4 years total. It was not a foreign concept that a piece of legislation could be passed as a solution to a problem plaguing the U.S. at one moment. The 14th's purpose was not to protect universities who want to grant certain races more educational opportunities than others. It was to protect the freedmen.
Let's assume that the framers of the 14th Amendment thought that the people of African descent deserve certain race-conscious privileges due to the unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
If we assume that the framers of the 14th Amendment thought that people of African descent deserved race-conscious privileges due to their unique history, we can also assume that the framers would not extend those privileges to other races without sufficient evidence of a unique and discriminatory position. The intention behind the 14th Amendment and the race-conscious legislation passed at the time was to protect African Americans from the Black Codes that Southern states had enacted after slavery was abolished via the 13th Amendment. These Black Codes created yet another system of slavery by stripping away rights and exploiting labor through forced contracts and corrupted bail systems. Perhaps if at the time of the Black Codes there arose another set of Hispanic codes or Asian codes, the framers would have awarded those groups the same privileges. Additionally, concerning Native Americans, although we can acknowledge that they experienced discrimination and suffering at the hands of the U.S. government, they would not have received the same privileges as African Americans. This is because, as aforementioned, the affirmative action legislation was passed to aid African Americans in transitioning into society. In contrast, Native American citizenship and sovereignty was still being hotly debated at the time of the Reconstructed era, meaning that they wouldn't have received similar privileges because they weren't being integrated into society. Therefore, the reparations would have to be given in a different way.
What would the framers of the 14th Amendment have thought about affirmative action policies that benefit people on the basis of sexual orientation or gender identity?
It may be tempting to assume that because the framers of the 14th Amendment created legislation that benefited freed African American slaves, that they would also be in support of legislation for other minorities like women and gay people. However, it is clear that the framers and other politicians were comfortable with the societal position of women by their exclusion of women's voting rights in the 15th Amendment. Additionally, the framers would have not been in support of special privileges being granted to people because of their sexual orientation, due to the concept of gay rights not even being considered at the time. Thus, the framers of the 14th Amendment would have not been in support of extending affirmative action policies on the basis of sexual orientation and gender identity.
Does Brown v. Board of Education prohibit race-conscious affirmative action? In your answer, please address Bakke and Grutter.
Brown v. Board of Education prohibits race-conscious affirmative action, as the ruling was meant to achieve a system of determining admission to public schools on a non-racial basis. This same logic should apply to race-conscious affirmative action programs for college and universities, as these admission processes are creating modern-day discrimination based on race. One of the main rulings of Bakke was that diversity is an acceptable, compelling state interest and satisfies strict scrutiny. However, diversity can be attained through a multitude of ways, not just race, such as socioeconomic factors and life experiences. Grutter took this one step further, establishing that race could be viewed holistically as a factor in admissions. Because the court permitted this, admission officers, in theory, can use race holistically for consideration. In practice, though, and especially in the University of North Carolina, race is seen as a tool or calculation for a worth of a student in creating a diverse campus. This is not what Grutter envisioned, nor is it how Brown should be applied today.
In 2003, Grutter observed that 25 years after this case, the use of racial preferences will no longer be necessary to further the interests of proof today. Will there ever be a point in time in which racial preferences are no longer needed? If not, should the court allow racial preferences to go on forever?
Sandra Day O'Connor's observation was correct, and today is that point where racial preferences are no longer needed. Social progress and awareness has advanced to the extent where racial discrimination still exists, but at a scale that would not affect the admission rates of students or promotion of military officers. The purpose of establishing racial preferences and affirmative action programs is to advance society to the point where we are no longer in need of them and they become moot. If the purpose behind the creation of these programs is that they go on indefinitely, how can we ensure their success? What is the end goal? That's why these programs are created with temporality in mind.
Should Grutter versus Bollinger be overruled? Please address the Supreme Court's recent decision of stare decisis in Dobbs v. Jackson Women's Health Organization.
Grutter v. Bollinger should be overturned. In the recent ruling of Dobbs v. Jackson, the Supreme Court chose to not follow the stare decisis established in Roe v. Wade. As Justice Alito said in his majority opinion, stare decisis is not an inexorable command, and the same reasoning can be applied to Grutter. There are many cases that establish the precedent for affirmative action. However, they are not permanent. Otherwise, why would the court have the ability to overturn them? Affirmative action is creating a system in which race is seen as the only way to promote diversity, when there are a multitude of other options. Curating a diverse campus, as is the compelling state interest in universities, is not as simple as regulating the percentages of minorities who attend the school. By hyper-focusing on race, colleges are placing important factors like political ideology, life experience, values, leadership qualities, and many others aside. Therefore, it is our belief that in order to create an equal opportunity admission system and a diverse campus, we must overturn Grutter v. Bollinger.
If the court declines to overrule Grutter, can the plaintiffs prevail?
If the court decides to not overrule Grutter, we believe that the plaintiffs will still be able to prevail in the case. If they choose to not overrule and keep affirmative action, they can still place stricter regulations and limits to how admissions officers look to prevent it from becoming the dominating factor in admissions. This would not ban affirmative action, it would just limit the consideration of race in admissions. Race can still be looked at both holistically and as a very small fraction of the overall admission decision. In this way, the court can keep Grutter and affirmative action while still satisfying the needs of the plaintiffs.
If the court overrules Grutter, will the military have difficulty recruiting a diverse armed service?
If the court makes a decision to overrule Grutter, it will likely leave the military unaffected. Grutter has no impact on the recruitment of a diverse armed service. Additionally, the intention behind diversity for an armed service and for a campus is very different. Colleges are focused on raising members of a society who are educated, have diverse outlooks, and know how to socialize with people different from them. The military needed affirmative action for the past few decades because of the rampant racism and discrimination that minorities faced in the military hierarchy. However, currently, the diversity rates have skyrocketed. Some may attribute that to affirmative action policies. However, we as a society have progressed far enough away from the ignorance of the past that there is no conclusive proof that eliminating race-conscious systems will instantly remove diversity from the ranks of the military. Therefore, it can be safely assumed that the levels of equality we as a society have strived towards will not so easily be destroyed.